Hey y'all, I'm Hannah Hill. I'm the Executive Director of the National Foundation for Gun Rights. I'm here with our Chief Legal Counsel, Barry Arrington. We are here in Chicago, Illinois, just outside the building where the 7th Circuit Court of Appeals just held oral arguments on our case Bevis versus Naperville. That's our challenge to Illinois' assault weapons ban as well as the City of Naperville's AR-15 sale ban. So we just had oral arguments with the 3-judge panel here. So Barry, can you first give us an idea of exactly what oral arguments constitute and what that means?
Sure. So a little bit of background in this case. We filed this case last fall just for the City of Naperville, and then the state of Illinois passed their ban in January, and so we added them to the case, and we went to the district court asking for an injunction. This is the Bevis case. And the district court said no, so we appealed to the 7th Circuit Court of Appeals, which is this court behind us, and they said no, we're not going to grant you an injunction either while this appeal is pending. And as you guys might remember, we went to the United States Supreme Court, and Justice Barrett took the case and had it briefed, and in the meantime, the 7th Circuit said basically to the Supreme Court, no need to get involved at this point, we're going to put this on what is colloquially called the rocket docket. And so our case was responsible for advancing this case by probably about 6 months in advance where we otherwise would be in terms of dealing with these issues. And so the Supreme Court said, okay, now that you're putting it on the rocket docket, go ahead and consider it. So that's where we are. We finished our briefing. We filed our opening brief, the state and the cities filed their briefs, and now after the briefs are filed, there's a time for oral argument. Now in the meantime, there were several other cases in the Southern District and the Northern District that were filed, and those district court cases came about as well, with varying degrees of success or failure, and those got consolidated into our case. But the bottom line is, this is the National Association for Gun Rights case that everybody's kind of latched onto and tagging onto, and that was the case that was argued today.
Right, and the reason we had asked for that initial injunction pending appeal, first we asked for a temporary restraining order, right? Because the case started in Naperville with our good friend Robert Bevis, who owns Law Weapons and Supply there. Essentially, his city council passed an ordinance that was going to basically put him out of business. So our goal was to get him operational. Our goal was to get him back in business so that he could sell his core product again. And then when Illinois passed their semi-auto ban afterwards, then we expanded the case, right? So that's where it started, and that's why we were further along in the litigation process when the state passed their ban, and so that's how it happened that we were actually the lead case here. So one question, so you mentioned the fact that that an oral argument is based on the briefings that we'd already submitted to the 7th Circuit. In a nutshell, what was the summary of our arguments that we told the 7th Circuit?
So the plaintiffs, the plaintiffs were consolidated for the oral argument, and not all the plaintiffs' lawyers all got up and argued today, but it was a consolidated argument. The plaintiffs basically said this is a simple case, and it is a very simple case. Tens of millions of people own these arms for lawful purposes. And under the Supreme Court's precedents, that's all that's necessary for them to be protected by the Second Amendment. And the state tries to stand up and say, no, it's much more complicated than that. Well, it's not much more complicated than that. But the argument came through. We made the argument. We should prevail. If we don't, we'll keep fighting. We're not going to stop fighting until we prevail. And if that means going back up to the Supreme Court, which is an option, that's what we'll do.
And the Supreme Court is actually already watching this case. I mean, we know that because when we asked them for the injunction pending appeal, they didn't say no until the 7th Circuit had put us on the rocket docket. And that fits with the way the Supreme Court has treated gun cases ever since Bruin. Their posture has been, we're interested and we're watching very closely, but we want to wait to step in until the lower court process has finished, which means that when we finally get back on the merits, we'll have a very, very good chance that the Supreme Court, which has already expressed its interest, will be taking the case. So we do think that the Supreme Court is certainly going to have to decide the issue of semi-auto bans.
Ultimately, the Supreme Court is going to have to weigh in because remember, this is not the only case in the country. There are lots of cases.
Right.
I mean, we ourselves have brought nearly a dozen. And this is percolating around the country. And as that percolation comes up, the Supreme Court's going to weigh in and resolve this particular issue.
Right. So we are prepared to keep fighting. We'll fight all the way to the Supreme Court if we need to. And as far as the oral arguments today goes, you alluded to the fact that the other side likes to try and confuse the issue, bringing up cases and issues that we're not litigating. What we're litigating is a semi-auto ban here in Illinois and a local AR-15 sale ban in Naperville. The Supreme Court has been very, very clear. That's not consistent with the Second Amendment. And by the Supreme Court's test under Bruin, there's no way you can defend those kinds of bans under the text, history, and tradition of the Second Amendment. So we have every confidence that we will ultimately prevail on that.
For example, the state of Illinois says, well, in the colonial times, they regulated the storage of gunpowder, and therefore we can ban AR-15s. That's a non sequitur. Their conclusion doesn't even remotely follow from their premise. But that's, they really got nothing. And so they're coming up with these sorts of arguments to see if they can get activist judges who are anti-Second Amendment to latch onto that, which is why, and unfortunately, there are plenty of judges like that. Hopefully the panel that heard this today is not going to be amongst those. But the fact that not all the judges, the inferior courts, are on board with Bruin means that the Supreme Court's probably ultimately going to have to resolve this again, make another statement loud and clear in this particular context.
Right. So if you've been helping us fight these cases, we thank you from the bottoms of our hearts. It's our members' support and backing that has made it possible for us to be here fighting today. If you haven't, we would ask that you consider chipping in to help us continue to protect and fight for your Second Amendment rights, and all the way to the Supreme Court if necessary, and we do think that will be ultimately necessary. So there's a link where you can contribute in the description below. We'll put a couple of other links down there where you can read more about the case, including Barry's awesome brief that he submitted to the Seventh Circuit earlier in this process. And stay tuned for more updates. We have a lot more lawsuits, and we will have more news for you soon. Thank y'all so much.